Hi folks, you're with Tacitus today at your Pushback channel. While you're with us, please take a moment to subscribe below and don't forget to hit that bell symbol for notification. In this essay, we need to have a conversation about how SJW madness has bled its corrupting ideology into the Western legal system. In legal terms, we live in interesting times. Over the last 30 years or so, the law and certainly due legal process has been politicised beyond recognition. What was once law and facts and evidence is now some miasma of ideological social equity. Gender, race and sexual proclivity form the fault lines, recording shocks well up the Richter scale and assaulting the legal system on a near daily basis. Consider, for example, the Me Too movement, where any and all allegations of impropriety against males, no matter how flimsy, I don't know when, I don't know where, I don't know how, are tantamount to a public conviction. Note how many jump on this hysterical SJW mob bandwagon and how few, so very few, come to the defence of due legal process. Even the top law officers of Western nations either abet or just go AWOL when these things happen. Every time a Me Too event flares and a career or position is lost, due legal process is, by extension, viciously beaten and pack-raped and left to fend for itself. Even many of those constitutionally sworn to protect due legal process in our laws have now become its enemies. Like neo-Marxist gender law, such as we see in the divorce industry and the campus star chamber rape tribunals starting up all around California in the late 1960s and beyond, we also have California to thank for neo-Marxist racial laws, and both of these categories are neo-legal gambits and are throttling the life out of due legal process in the West, and with it one of the vital cornerstones of public trust and the functioning of the democratic civis. I believe a first-rate early example of creeping activist race law jurisprudence is the case of African American Rodney King. In 1991, Mr. King was clocked speeding and police attempted to stop Mr. King and issue a ticket. However, King sped off in the motor vehicle, causing a police chase with additional officers joining the pursuit. When the car was finally stopped, 26-year-old King, already known to police, repeatedly refused to follow the lawful directives of the arresting officers involved. The officers then used considerable force to finally subdue a physically strong Mr. King, and it was later argued the force may have been excessive. A video of part and only part of the incident was taken by an onlooker, which was breathlessly and sensationalised by the media. The case went to trial. What is most interesting in this case, and we are talking about almost 5 years of ongoing litigation across 5 courts, is how the criminal facts of the case were not in dispute. The defence appeared to accept all the primary charges, but instead of arguing the guilt or innocence of their client, the defence, with the total support of the California legal infrastructure, turned the trial and subsequent trials into a race conflict extravaganza more befitting a third-tier college sociology lecture room than the hopefully more sober setting of an evidence-based court of law. The SJW script was evil, hateful whites against oppressed blacks, and it played out with all the class and race theatrics we now see as commonplace. This brought in completely subjective material to the court, such as SJW ideology, leftist talking points, and fuzzy phantoms, such as ideologically asserted but never clear civil rights. During the trial, the officers were subject to lengthy and tiring cross-examination by relays of activist lawyers who were allowed, and many would say assisted, by some of the judges as to their views, their attitudes to race issues and blacks generally. The near hysterical race baiting by allegedly leftist activist attorneys get the officers to say just one unguarded word that could be seized upon or interpreted in any way as racist continued for hours and days. The bar for what might constitute a racist remark was set very low. But were any of the black people involved forced to deny they didn't like or hated whites? No, of course not. It was all one way and has remained so to this very day. All the officers were acquitted, which brought on riots in the black areas of East LA. Later, the left-leaning California-based Ninth Circuit Court of Appeal declared 2 of the officers guilty, and then a higher court overruled that lower court judgment. Mr. King, meanwhile, sued along civil rights lines and received a most handsomely proportioned compensation payout of $3.8 million from the near-bankrupt city of Los Angeles. Over the following 10 years, Mr. King received multiple fines for speeding, negligent driving and drink driving. Many would argue this case and trial set the standard for bringing SJW ideology, and particularly race ideology, into the legal picture, which in turn transformed courts of law into star chambers of ideological social equity, which in turn again have emasculated the centrality of the actual crime that brought the case to the court in the first place. We live with the full force of all the cascading consequences of these events today. The black activist and SJW view that all black crimes are inseparably bound to ideological race issues, to the point where the crime committed is minimally relevant. Moreover, the activist position that the entire legal system, including law enforcement, is illegitimate for this reason and can be ignored and disobeyed without consequence to blacks. Thinking persons should have stopped it then in 1991. I know it's not rocket science to see where it was heading, but we all should surely stop this madness now. Oh, and wherever and whenever you see due legal process being undermined or attacked by Me Too or any other rabid, spitting mob, fearlessly come out in its defence. Stare them all down. You've been with Tacitus today at your Pushback channel, and thank you for listening.